There was an interesting case decided last week in the Supreme Court about environmental issues and environmental reviews. It's an 8-0 decision. Justice Gorsuch did not take part, and Justice Sotomayor, writing for the three liberals, wrote separately in a concurrence, concurring in the judgment, but for different reasons. The case is called Seven County Infrastructure Coalition versus Eagle County, Colorado. Seven County Infrastructure Coalition applied to build an 88-mile-long railroad to transport oil from Utah, ultimately going to the Gulf Coast to be refined. The application requires the preparation of an environmental impact statement, which was done, and the government considered the effect of the railroad and also tangentially the effect of drilling for oil and refining the oil, not directly the railroad itself, but upstream and downstream effects of the railroad. The plaintiffs asserted that the government limited its analysis impermissibly of the oil drilling and the oil refining, and they should have taken that more into account when approving the railroad. The court said that the focus of the statute is to look at the proposed action, in this case, the railroad, not the upstream and downstream effects of the railroad. The court said this at the bottom of that first paragraph. Therefore, when the effects of an agency action arise from a separate project, for example, a possible future project or one that is geographically distinct from the project at hand, NEPA does not require the agency to evaluate the effects of that separate project, in this case, the oil drilling and the refining. But such effects might fall into the purview of NEPA. For example, they say in the middle paragraph, runoff into a river that flows many miles from the project and affects fish populations elsewhere, or emissions that travel downwind and predictably pollute other areas. But, the court said, if the project at issue might lead to the construction or increased use of a separate project, for example, a housing development that might someday be built near a highway, the agency need not consider the environmental effects of that separate project. But this is giving deference to these agencies. What about getting rid of Chevron deference in the Loper case from last year? The court cites Loper Bright Enterprises, which is the case that overruled Chevron. And the court said when an agency exercises discretion granted by a statute, then judicial review is the arbitrary and capricious standard, a pretty high bar to overrule an agency. Under that standard, a court asks not whether it agrees with the agency decision, but rather only whether the agency action was reasonable and reasonably explained. The court said that the action was reasonable, was reasonably explained, and allowed it to stand.